Hello and welcome to our webinar Posting Workers to Finland. I'm Inspector Riikka Mandelin from the Regional State Administrative Agency for Southwest Finland, and I'll be the host in this webinar. Before we get started, I'd like to say just a few practical issues. Just a moment if we see the right slide, the number 2, if you please. Yes, okay. So here you can see the direct link to our website where you can download these presentations, and also from the same address you can later on view the recording of this webinar. So it's good to know that this webinar will be recorded now as we speak. If you have any questions, please use our chat. We have experts here just to answer your questions. So put your answers there, please. This webinar is organized by the Occupational Safety and Health Administrations, and we are also the authority here in Finland that supervises the Posted Workers Act, of course, among other labor legislation. Today, we'll tell you about things you as an employer need to know when you are posting workers to Finland. If you'll go to the next slide, Anu, and we'll see the program of today. Can you change to the next slide?
It shows me the third one.
Okay. Now, in the program we have what is posting first of all, then we'll also talk about employers' obligations when you're posting workers to Finland. And then also quite important are the upcoming changes later this year in the reporting notification. We'll tell more about that as well. And in the end, you'll get our contact details so that, of course, if there are any questions later on, feel free to contact us after the webinar as well. But now enough from me, and let me introduce you to our speakers of today. We have lawyer Anu Ikonen from the Regional State Administrative Agency for Southwest Finland.
Hello.
And then we have Senior Inspector Katja-Pia Jenu from the Regional State Administrative Agency for Southern Finland.
Hello and welcome.
Without further ado, I'll give the mic to you, Anu.
Thank you, Riikka, and welcome to this webinar on my behalf too. If we change to the next slide. Okay, we receive often questions about specific responsibilities of the posting company, but in many cases we have to first determine is the situation actually posting? And that's why we start with the question, what is posting? Posting means that during workers' employment, the worker is posted to Finland by the employer to perform temporary work for a limited period of time. So normally, posted worker is working in some other country than Finland, and the employer should be performing significant activities in another country than Finland. And the posting should be a temporary work, in other words, time-limited period work in Finland. So as a conclusion, posted workers should have been working before for the employer in some other country and returns to work for the employer to another country after working in Finland. You can find more information about posting from our website of the posted worker. Some typical situations that are not considered as posting. One is that a foreign company hires a person already living in Finland or directly to Finland. In these cases, the posted worker hasn't been working for the posting company in another country before working in Finland. Business trip is a very common question, and they are not considered as posting since they don't include work based on an employment contract. And self-employed, they are not considered as posted workers. There is no employment contract, and they are, in a way, employers themselves. The Act on Posting Workers lays down the obligations of the posted company, and it applies to the situations where work is carried out in Finland under an employment contract by a worker posted from another country based on an employer's contract on cross-border provision of services. This can be subcontracting, intra-group or intra-company posting, or temporary agency work. The Act doesn't extend to the self-employment, as I previously said. There are no time limits for applying the Act on Posting Workers, so no minimum or maximum time limits in the legislation of posting workers. There might be time limits in social security rules or A1 certificate matters, but it is good to know that posting in Act on Posting Workers and social security rules cannot be compared. Act on Posting Workers defines also the parts of the Finnish employment legislation which applies to posting. There are parts, for example, from the Work Time Act and Annual Holidays Act. And you can find more information on the applicable legislation on our website where the acts are listed. So what to start with when posting workers to Finland? In the beginning of posting, timeline is the reporting duty. So before the work begins in Finland, the posting company must submit a notification to the authorities. And this before means before. It can be the same day, but it needs to be done before the work actually begins. There is no other time limit for doing the report. If given information changes significantly, a supplementary notification must be done as soon as possible. And the significant changes, they can be changes, for example, on contact information or the representative in Finland, the length of posting, and of October 1st, changes of workers. The reporting duty is fulfilled by filing the electronic form you can find on our website. The negligence fee can be imposed if posting company neglects the reporting duty. So in cases the notification is not made at all, or it has been made, for example, late. Reporting is not needed when workers are transferred internally within the company for a maximum of 5 working days. It is good to know that the exception doesn't apply to subcontracting or temporary agency work and when working on construction sites. So in every case, if you are working on construction site, the reporting duty must be fulfilled, even if it's internally, if you are transferring internally within the company. And all previous posting periods, meaning working days, or the last 4 months during which workers are sent to Finland are taken into account when you are calculating of these 5 working days. And with this picture, we are illustrating the calculation rule. So what is the 4-month period during you can send maximum of 5 days without doing the reporting? The posting companies are required to provide detailed information of the posted workers in the beginning of October. So this means a personal data necessary for the identification of each posted worker. Posted companies need to provide personal ID of the posted worker, the tax identification number of the state of residence, and if you are working on construction sector, the tax identification number given by the Finnish tax authority. If at that point you are doing the report, it has been given. And then the beginning and end dates of the posting or the anticipated end date, and for each posted worker. The new electronic form will be published at the end of September, and you can find more information on the website. Another notification that we have is the notification of extension of posting. So after working in Finland more than 12 months, it is considered as long-term posting, which means that some additional employment conditions should be applied. This means in practice paid absences based mostly on our collective agreements, such as employees' 50th birthday, the funeral date of a close relative, or some obligations to pay sick pay, for example, a longer period of time. So at the recent request of the posting company, this 12-month period may be extended to a maximum of 18 months. And this means that the additional working conditions for long-term posting will then only start after the notified extension, if the posting continues in the same job at the same workplace. And in practice, the application of the additional employment conditions will take place in 1st of December this year, as the calculation of the minimum time of 12 months began 1st of December last year. One of the oldest responsibilities of the posting company is selecting a representative. This means that the posting companies must have a representative in Finland whom the posted workers and the authorities can contact all times during the posting. And in practice, this means that the representative must have a postal address in Finland, and the communication with the authorities is carried out via the representative. This means that we as POS authority are sending, for example, inspection notifications and inspection reports to the representative, and the representative then forwards them to the employer. It is good to know that the representative doesn't bear the employer's responsibilities. A representative doesn't need to be selected in case the posting is no more than 10 working days in duration. And in this case also the past 4 months are taken into account when calculating for these 10 working days. So you can see the slide 11 and the picture of this calculating rule. If the selection of representative is neglected, authority can impose a negligence fee. As the posting companies can also be contractors in subcontracting chains, it is good to know that the contractor must ensure that the posting company selects a representative. And ensuring means that you have, for example, specified this in the agreement, or by other means, for example, by email. You are telling that there is this kind of responsibility in Finland when posting workers. And on our request, the contractor must obtain information from the posting company on where and how the representative can be reached and give this information to us. This means situations that we are not able to contact the posting company and the representative in Finland. Then we can contact the contractor and ask for this information. And only in these cases, if the contractor is not acting on behalf of our request and ask for the information about the representative, a negligence fee can be imposed. One of the most important obligations is to keep available required information during the posting. Posting company must always have the identifying details of the posting company and identifying details of the posted worker and information on the posted worker's right to work. Also, the information on the posted workers' terms and conditions of employment. This information must be available for immediate use, but it can be stored, for example, in electronic form. But on inspection visit, they must be printable if we ask that during the inspection. When posting is longer than 10 days, posting company must also have a record of working hours and payslips and document issued by a financial institution of the wages paid. And this means a receipt of the payment of the wages. And if this responsibility of keeping information available in Finland is neglected, we can impose a negligence fee. The negligence fee is between 1,000 to 10,000 euros, and we can impose negligence fee to the posting company if the posting company fails to report the posting of workers or performs the notification late, or the supplementary notification is not done after significant changes. And then if the posting company fails to ensure the selecting of a representative in Finland or fails to keep the required information available. And then the contractor may be imposed for the negligence fee if the contractor neglects to find out from the posting company on where and how the representative can be reached and or give this information to the POS authority. And then I will give the floor to Katja-Pia.
Thank you, Anu. I'm going to talk about the posted workers' right to work in Finland. This regulation is not in the Act on Posting Workers, but in the Finnish Aliens Act. You can find this graph you can see on the slide at our website. The first important rule is that only EU and EEA citizens can work freely in Finland. Third country nationals always need a permit unless the work carried out is specialist work. The main rule is that in order to work in Finland, third country nationals should apply for a residence permit in Finland. There is, however, an exception that enables third country nationals with the work and residence permit in the posting country to work in Finland for a limited period of time. But there are certain criteria that have to be met. First of all, the worker has to be a posted worker, and the posting company has to be established in another EU or EEA member state. The work carried out in Finland has to be temporary work, and the posted worker has to have a work permit in the EU or EEA country, and the permit has to be valid after the posting in Finland has ended. Then there are certain criteria for this work permit, because the posted worker has to be a permanent employee of the posting company. This means that, first of all, the employment contract has to be made until further notice, and also the work and residence permit in the posting country must be valid for at least 1 year. So only if all these criteria are fulfilled, then the posted worker is allowed to work in Finland for 90 days within the period of 180 days. Next one, please. Then about applicable legislation. The terms and conditions of employment of the posted worker are determined according to the legislation of both the country of origin and Finland. However, the posting company and the posted worker cannot agree that only the legislation of the posting country is applied. For example, certain provisions of the Finnish Working Hours Act and Annual Holidays Act must be applied if they are more favorable to the worker. Also, Finnish Occupational Healthcare Act, Occupational Safety and Health Act, Non-discrimination Act, and certain provisions of the Finnish Employment Contracts Act are always applied. You can find more information about the applicable legislation at our website. Next one, please. Then about the minimum wage, which is a very important topic. In Finland, the law does not specify a minimum wage. Instead, in Finland, the minimum rates of pay and its different components are normally determined in accordance with the collective agreements. If a collective agreement is universally applicable, all the companies, including posting companies, must follow the salary rules of that collective agreement. It's good to know that unions publish their translated collective agreements in their online services. Next one, please. It is very important to find out which particular collective agreement is applied in your line of work. All the universally applicable collective agreements can be found in the internet in Finnish. The collective agreements determine not only the basic salary, but also all the extra components, salary components, which must be paid to posted workers as well. Next one, please. In many collective agreements, the salary is determined by how demanding the job is or how skilled the worker is. Therefore, it is not acceptable to pay level 1 salary, which is normally aimed for trainees or unskilled workers, to a professional worker, and this applies to both Finnish workers and posted workers. It's also important to notice that all the extra salary components included in the collective agreement must be paid to posted workers. Next one, please. If work is carried out on Sundays or on church holidays, on May Day and the Finnish Independence Day, which is the 6th of December, there is always a salary increase of 100%. This salary increase cannot be included in the basic salary. And overtime work must always be compensated either in money or in increased free time. This means that if the posted worker has 100% overtime, it equals to 2 hours off, not just 1 hour off. Next one, please. Then about special compensations. If special compensations and allowances are paid as compensation of actual costs due to posting, then they are not considered part of the posted workers' pay. In practice, this means that per diems and travel cost payments and accommodation compensations and meal compensations cannot, as a rule, be included in the salary. They have to be paid on top of the basic salary or the salary that is determined by the collective agreement. Next one, please. Then about the prohibition of discrimination. Like I mentioned earlier, the Finnish Non-discrimination Act applies to work performed by posted workers in Finland. The reasoning behind this is, of course, to prevent discrimination of workers, but also to prevent enterprises from gaining advantage from violation of minimum terms of employment. In practice, this means that paying too low a salary to a posted worker can be discrimination, and it also can be a criminal offense. The OSH authority, we have got the duty to report suspected work discrimination and extortionate work discrimination cases to the police, which then investigates the cases. The OSH authority cannot impose any fines on criminal cases. Next one, please. Then about the working hours. In Finland, regular working hours are often specified in collective agreements. So collective agreements play an important role not only in the determination of the salary, but also as far as working hours are concerned. Often in collective agreements, the working hours are less than the regular working hours in the Working Hours Act, which are 8 hours per day and 40 hours per week. The Working Hours Act also specifies what is considered overtime, the rest periods between shifts, and the requirement for keeping records of the working hours. Next one, please. It is possible to arrange the working hours as average working hours, but this means that there has to be a working hours adjustment system has to be made in advance. It's very common that only later the companies say that instead of paying overtime compensation, there is an adjustment system, but if it's not made beforehand, it's not valid. In the collective agreements, there are also regulations on the length of the adjustment system. Next one, please. Overtime is work exceeding the regular working hours, and there can be daily overtime, which is after 8 hours, or weekly overtime if the working hours exceed 40 hours per week. Overtime work always requires employees' consent, and it's important to notice that the employee cannot commit in the employment contract to working overtime, but it has to be agreed always separately. And also overtime must always be compensated separately, and overtime compensation cannot be included in the normal salary. Next one, please. The maximum number of hours that the employees can work are, according to the Working Hours Act, approximately 2,300 hours, which equals to about 48 hours per week. So in Finland, since 2020, instead of monitoring just the amount of overtime hours, the new Working Hours Act has got the rule of monitoring the total hours at the workplaces. This is important to notice. Next one, please. Then about statutory accident insurance. The main rule is that posting company working in Finland must take out a statutory Finnish accident insurance for their employees. And I stress the statutory Finnish accident insurance. And therefore, the insurance policy taken abroad is not valid for this purpose. Next one, please. However, there is an exception. If a posted worker coming from EU or EEA member state has a valid A1 certificate, then the posting company doesn't need to take the accident insurance in Finland. But for posted workers from a third country, the only option is to take out the accident insurance in Finland. Next one, please. Then about occupational health care. According to the Act on Posting Workers, the posting employer is required to provide his employees with statutory occupational health care in Finland. And this obligation exists even if the duration of the work is very short, so there are no exceptions. It is possible to make arrangements where the user company organizes occupational health care for the posting company as well, but the posting company must be able to present a written agreement about this arrangement. Next one, please. Occupational health care consists of a written agreement with the Finnish occupational health care service provider and a plan of detailing how the services are to be implemented. There is also a workplace survey, which the occupational health care service provider performs, and basis on which writes up a report. A similar service arranged in the country of origin cannot replace occupational health care organized in Finland. This is a very common question we have. So the law is very strict on this. Next one, please. Then about tax number and photo ID. This regulation applies to posted workers working at construction sites, and also starting from next year, 2022, it's applied also at shipyards. So all the workers, both Finnish and posted workers, must have a photo ID, and the photo ID must first of all show whether the person is an employee or an independent contractor. There must be name and photo of the person on the ID card, and name, if the person is employed, the name of the employer, and then the Finnish tax number. And it's important to notice that the tax number must be entered in the Finnish tax number register. You can find out more information about the tax numbers at the Finnish Tax Authority's website. And now I give floor back to Anu.
Thank you, Katja-Pia. We, as OSH authority, are monitoring the workplaces. So we do inspections at the workplaces, monitoring traditionally the safety and health matters, employment matters, and also posting legislation. We give advice and guidance to the both sides, employers and workers as well. Labour Authority cannot represent the interest of the parties. So one of the most common questions is that can we claim, for example, for the missing salary? But the answer is no. We are monitoring that the legislation is obeyed and give inspection reports to the employer, but we cannot claim, for example, for the missing salary. And we are not able to assist in filing a lawsuit or provide legal counsel in court, as Katja-Pia mentioned before. If we suspect a work-related crime, we do make a notice to the police, and then it will go forward as a criminal case. Then, how to contact us. When contacting us, you should first find out the correct agency, which is determined according to the place of work. So finding the regional competent agency is first thing to do. Inspectors of foreign workers are able to give you advice about posting situations, and you can contact us by mail, and you find the contact information and addresses from our website. By email, you can also contact us, and here is the map to show you the regional areas of the agencies, and then the contact information, the email addresses to the correct agencies. We also have a telephone service, and in English it gives service from Tuesday to Thursday from 9 to 12 a.m. So there you will also be able to get instructions and advice from the health and safety questions and employment terms. Then I think I will give the floor to Riikka.
Yes, thank you very much, Anu, and thank you, Katja-Pia, also for these presentations. I think there was a lot of information here on these slides, so don't worry, you can return to all of this information and download the slides from our website, the address that you already received in the invitation, and it was on the beginning here as well. Now what we would really appreciate is a little feedback on how we did on this webinar. On your screens you should see a short survey or a poll. If you'll just take a few seconds to answer it. And we'd appreciate that a lot. Also, if you like, you can give feedback to us by email. You can see the address on the slide and copy it straight from there. Or questions that may come later, feel free to contact in our posted workers email address here. As it says here, also the chat will be open for another 10 minutes after we end the webinar, and I think there's been a lot of good questions. Thank you for that, and I think that there are still some of you waiting for the reply, so we'll have still time for that. And don't worry if you still have any questions. As I said, you can also send them later on. But I think that that's all from our presentations for now, and all from me, and we'll let the chat continue still, but at this point we'd like to thank you for participating, and you can change to the last slide, Anu, if you please. With this last logo slide, as I said, thank you for the presentations and thank you for hearing us, and don't hesitate to contact us also later, and I'll let the chat discussion to continue, but that's it from me at this point, so thank you very much.